Good morning and welcome to our webinar on trends and changes in procurement on this Wednesday, May 29th, 2019, or as some of us like to refer to this, the day before Raptors make history in the NBA Finals.
Yes, let's hope.
Thank you for joining us this morning. I will be it's Paige Backman. I'll be facilitating this discussion in procurement. I'm head of the corporate commercial department at our firm. Leading these discussions will be Don Johnston, the head of our technology and procurement department at our firm, and joined with him is AJ Gajaria, who's a recent hire at our firm in our municipal department, and we're absolutely thrilled to have you join us, AJ. So thank you.
He's so smart. He's really smart. I've worked with him already. He's terrific.
Yes. All right. So I'll turn it over to Don and to AJ, and then we'll get started.
Well, thanks, Paige. And it's great here to be in our fabulous new Airden Burles studios with a commanding view of downtown Toronto, isn't it? It's wonderful.
Yes.
Yep. And good morning, AJ. So the subject of procurement is a bit of a mystery for all kinds of people, and maybe what we should do to get started is to have an initial review of some of the principles that are involved with procurement here in Canada, and we could maybe chat a little bit about what that means. So. Going way back, and I don't want to spend a lot of time on this because, a lot of people who are listening in probably know this stuff very well. But it all goes back to the dark ages when the Supreme Court of Canada ruled in the case of Ron Engineering. And the issue there really had to do with how do you conduct a procurement in such a way that the integrity of the bidding system is something that is preserved. In other words, you can rely on some kind of governance, some kind of rules or some kind of principles that really will protect both the buyers and the sellers in the course of a procurement. And in this particular instance, the Supreme Court of Canada came up with this idea that there are actually two contracts in every procurement. There's something called contract, it was called Contract A. They could have called it Contract 1, but no. The Supreme Court's smarter than us. They called it Contract A. And the idea there is that every bidder who submits a compliant bid in the course of a procurement enters into a Contract A with the buyer. Now, of course, you know that later on we're going to say that's not true, but if the circumstances are right, the compliant bid will create a Contract A. And of course, if you think about a typical procurement, there might be, let's say, a dozen bidders, all of whom are compliant with the bid requirements, so they all have a contract with the buyer. What is that contract? That contract is one that says, look, I'm the buyer, I'm going to be fair, I'm not going to give anybody a leg up over anybody else, I'm not going to have any undisclosed criteria for making my decision. I'm not going to behave like a moron. Basically the anti-scumbag concept of dealing with people in a fair way. I've heard it said that if you're equally unfair to everybody, that is compliant with Contract A, and sometimes that's the case. Contract B, which is the second of the two, is actually the contract that is entered into with the bidder who is selected by the buyer. It's the definitive agreement between the parties. And under another case called the Double N Earth Movers case that I just changed to on slide 3, what happened there was that the City of Edmonton accepted a non-compliant bid. In other words, they breached Contract A, if you will, and the plaintiff sued for breach of Contract A. City didn't know that it had breached. Why? Because somebody was not telling the truth in their bid. And the city didn't dig into it and find out whether it's true or not. They could have. But one of the things that I took away from the Double N Earth Movers case is that when you sign Contract B, Contract A essentially falls away. It's discharged and it's gone.
Wouldn't that support the principle that people can be willfully blind to deficient bids? But they don't have to, look through the surface, look through what's given to them.
Yeah, that's kind of an interesting question because a certain amount of willful blindness seems to be okay. In other words, you don't have to dig in. There's other cases that say that if you do dig in, it's not a bad thing because there have been allegations in other cases where a city has gone ahead without permission and verified certain things and really done its own background search behind the information that the bidder supplied, and then was accused of making a wrong decision on the basis of facts that were not in evidence. So it's really an interesting situation. So a little bit of blindness is all right as long as it's maybe not overly willful. I don't know. AJ, what do you think?
No, I would agree because there's also a practical challenge that I think the court was recognizing in this case and other cases that municipalities or cities or procuring entities don't always have the capacity to engage in a fulsome exposition or search through bids at whether or not they're compliant or not. In this case, they had a bid that was compliant on its face. I wouldn't say that would rise to the level of willful blindness because they weren't necessarily alerted to the specificity of the breach. Where if they were, I think that may be a different scenario to insulate them from the claim of willful blindness.
I think the issue there was that the bidder was supposed to be using equipment of a certain age and no older, and they supplied information about the equipment that they would be using. If the city had dug in a little bit, they could have determined that the equipment was older than specified or required by the mandatories in the procurement document, but they didn't do it. So I agree with AJ. I don't think they had to, and actually the court agrees with both of us, so we're good.
Great minds think alike. When you're advising clients in the procurement process, do you advise them to maybe dig a little bit to avoid a challenge like this? Or you have to be practical in terms of, look, we're strapped for resources. We're maxed out just reading the responses to these RFP processes.
There are two times when you have to dig in. The first is before you do anything. You have to familiarize yourself with the market, learn what's out there. And then the second time, of course, is to do reasonable due diligence during the procurement process. You have to signal to the sellers that you're going to do this. Otherwise you can be accused of having some kind of criteria that are secret. The fix is in or whatever, and that you're digging up reasons not to accept a particular bidder's bid. Remember that in every procurement, somebody's going to be unhappy if there's any competition at all.
One point, if we can I know you want to go through a number of your cases, so forgive me. Just for some members of the audience,
there's an audience? Wait.
Hopefully. Two questions that I would like to just lay the platform is the difference between public procurement and private procurement, and then the breadth of public procurement in Canada. Those entities coming from the U.S., Don, as you've suggested, and from outside of Canada may not truly appreciate how broad the public sector is in Canada and where those public procurement rules apply.
Well, yeah, the base common law rules, and AJ, jump in, please. The base common law rules for public and private procurements are the same. The case law, especially the several Supreme Court of Canada cases that are out there. But when it comes to public procurement, there are also trade agreements and other kinds of arrangements in place, policies, procurement bylaws, all kinds of stuff like that, that really, they don't take away from the base obligations that are contained in the common law, but they may add some additional requirements that, I mean, for example, trade agreements require you to behave in a certain way. If you, in the private sector, I could, if I wanted to, issue an RFP and create a vendor of record list for my big company, where we have 3 or 4 suppliers that we can choose for stationery or something. And it might be hundreds of thousands or even millions of dollars a year. That's okay, and that vendor of record list can last for 5 years, no problem. You can't get away with that. Am I right, AJ? In the public sector, because if it's a big enough contract, if it's over the monetary threshold of a particular trade agreement, well, there's going to be a complaint that that there's this list of legacy vendors and nobody can get in. Right? So it can be an issue. In CETA, the comprehensive economic and trade agreement that Canada entered into with Europe, actually those vendor of record lists are breakable, and so in fact it's possible for somebody to be added to a vendor of record list if the list is otherwise one of these legacy deals where you're in for life.
And in the public sector context, you may have an additional layer of reputational risk through political involvement, because it's about the spending of public dollars. So there is media coverage that may occur regarding an unfair procurement process, and the layer of political oversight where there may be complaints from an aggrieved bidder to the political oversight body with respect to the organization. So there are also additional, I would say, non-expressly legal layers in the public context vis-a-vis the private.
And in terms of the breadth of the public sector in Canada, for those coming in from the U.S., which we have a number of U.S. audience members, there's certain industries such as healthcare, which is in the public sector in Canada, which isn't in the U.S. So you've got to be a little bit more cognizant of the breadth of the application of public sector issues in Canada in procurement.
It gets complicated. And it's going to get more complicated because, for example, here in Ontario, and I expect to see this because of the ease with which technology can be applied to enable procurements to be done on a significant scale. Ontario is moving to something called, they call it the Lean and Continuous Improvement Office. I think they're trying to use the same letters as almost the LCBO, the Liquor Control Board of Ontario. But this is the LC, what is it? LCIO, I guess, yeah. And the idea there is that everything that gets bought in the Ontario public sector, and probably most, if not all, the broader public sector in Ontario, which includes, hospitals and the like, those procurements will be done through a central agency with a view to saving money. it'll be interesting to see how well that works. But that'll add a layer of complexity and may attract the attention of other countries as far as trade agreements are concerned, right?
I think that leads nicely into the next question for both of you to answer. How have things changed over the years in public procurement?
Go ahead, AJ.
So for municipalities, traditionally, under the Municipal Act in Ontario, we had a mandated requirement to have policies and bylaws with respect to procurement pursuant to Section 270 of the Act. The biggest change for municipalities in the last few years, I would say, is the application of trade agreements, specifically CETA, for procurements over certain threshold values. I always thought it was a little odd in the municipal context in Ontario that we have very specific prescriptive regulations in a number of areas, but with respect to procurement, a lot of it was best practices driven by the common law, but we didn't have a codification of principles and obligations. And I think we do have that now with CETA and the internal trade agreement for municipalities, and that's a really big and specific change for the municipal sector in Ontario, at least.
Yeah, we get a lot of calls from procurement folks in various municipalities who really are having trouble and rightly so navigating all this stuff. What are the thresholds? How do we have to how do we have to modify our purchasing bylaw? AJ and I had a discussion recently about a purchasing bylaw, and should the bylaw be generic in the sense that of just mentioning we'll comply with trade agreements, or do you mention the trade agreements? And a lot of municipalities really go back to the purchasing bylaw over and over again to make sure that they're in compliance, rather than having a more general purchasing bylaw and then policies and procedures that are consistent with the bylaw that can be modified and so forth as time goes on. So every time a new trade agreement comes in, you have to look at some of the fundamentals that govern the purchasing in a particular municipality. Now, some are small enough to maybe stay under the radar, but I think everything is game. If it's a big enough contract that even a small municipality could end up getting an objection from somebody in France or Germany, right?
So just a question from left field. Are you seeing any difference to procurement in Canada based on the trade wars that are going on internationally with, let's just say, the U.S., Canada, with China? Are you seeing any impact in the discussions around opening up, let's say, private procurement, opening it up to businesses in the United States? Any backlash? Are we seeing that right now?
I haven't seen anything arising from that, and now that you mention it, maybe I should be surprised.
Same as Don, I haven't seen anything specific.
So business as usual in the procurement sector, notwithstanding the wars that are going on and people closing their doors.
So far,
yeah.
So far,
right.
What we're going to see, I think, and maybe AJ, you could comment on this, is that. With the monkeying around with tariffs and duties that we're seeing, that has the potential to change the cost of certain imported goods. So, and nothing really is more sensitive to this than the technology market. And if you look at the kinds of technologies that companies and municipalities, governments generally have, they rely on technology that works with other technology. Every once in a while, you can get trapped into a technology that doesn't speak to anything else, and then you're stuck. You may have to do a sole source type of procurement. But at the very least, and whether it's a hospital, municipality, whatever, once you get into a particular kind of technology, you'd like it to kind of comprehensively work with everything else you buy. If there's a trade war going on and it changes costing, well, it changes costing. You know, your budget's blown, but you're still kind of stuck getting compatible technology. You can't just, switch to something else at the drop of a hat.
So I know you wanted to go through some more of the basic principles of procurement. When you do that, I guess the questions at the end of that part will be, what are the most important things to remember if you're the buyer, and of course, then the flip side, the seller. So did you want to just dive into that?
Just to finish the basic principles, if I go back to the first slide there, Ron Engineering, I talked about, the MJB Enterprises case was another one that the Supreme Court of Canada decided on. And basically, you can extract a lot from MJB in terms of fairness and whatnot, but the buyer can only really accept a compliant bid. The buyer can't have any undisclosed criteria for making a decision to buy. Has to be consistent with what's in the procurement document. But if there's a privilege clause, and there are all kinds of examples of this. Some of them are illegal. Some of them are okay. An example, the most notorious privilege clause, I guess, would be what they call local privilege, where a municipality will say, preference will be given to somebody who votes for us, or somebody in our municipality or in the county, that kind of thing.
Can you go into what a privilege clause is generally?
Yeah, it's something that gives the municipality or buyer an out from what would otherwise be a binding obligation. So if you're saying in a tender, very clear, this is going to be for snow clearance this winter over these particular roads, and here are the service level commitments that you have to agree with. So it's really crystal clear. Scope is and everything is there. Normally, you'd be obliged, everything else being equally, to take the bid of the lowest bidder, right? Save money. But a privilege clause might say, well, we can, and this would be an illegal privilege clause, we want to, we will give preference to a locally, a local taxpayer, a local company that clears the roads. So, those can be problematic. It also depends on threshold, because sometimes if the contract is below a particular threshold, you can get away with local privilege. If it's over the threshold where the local privilege offends let's say, the Canadian Free Trade Agreement, then you're a bad guy. So it all depends on the amount. And by the way, you can't just divvy the contract up into little pieces and make them all lower than the threshold. Nice try. You can't do that. So and then there was the Martel case, which really talked about fairness, and in complement to MJB, it said that the buyer has to reject a bid that's non-compliant. Sometimes you'll see buyers say, we reserve the right to ignore minor non-compliances. You see that in most procurement documents. And yeah, if it's minor, if it doesn't make a big difference at the end of the day, then it is okay. But you can't use that as a license to just ignore something that is really important. Give you an example. Maybe that would be the best. If a mandatory requirement is you have to submit your bid on a piece of paper attached as Schedule A, But you actually use a piece of paper that is not exactly the same as Schedule A, but answers all those questions in all the right order and so forth. That's probably a minor non-compliance, even though it's expressed as a mandatory. And if the municipality or buyer reserves the right to ignore minor non-compliances, then it may be that that's reasonable. If that right is not reserved, then it might not be reasonable. Agree? Yeah.
Absolutely, yes.
We talked about double-end earth movers. There's a horrible case of Selex Systemi against Canada and EADS on the fairness side. And this was kind of an interesting case. It's about fairness. But what happened here was that Selex Systemi was the successful bidder in a federal procurement. And one of the terms, and you see this all the time in federal procurements, is one of the terms is, thou shalt not assign this contract, sometimes either before or after the contract B is awarded. Well, Selex Systemi, for whatever reasons, I guess the lawyers and accountants got to them, God bless them, did a reorg. They did a reorganization, and in the context of the reorganization, to save $37 in tax, whatever it was, they incorporated a new entity and then assigned all the assets of Selex Systemi to this new entity. There was no change in ultimate control. Everything was the same, but the buyer said, "Oh, you've assigned the contract. Sorry, you're out." And then they awarded the contract to somebody else, and there was weeping and wailing, gnashing of teeth, rending of garments, all that kind of stuff. And of course, Selex Systemi lost that trial because, and that was Federal Court of Appeal, lost at trial because of that. Sorry, Federal Court, not Federal Court of Appeal. There are a number of other cases that are, there's a BC case on fairness. Acme against Newcastle was one, and this is really, I think, a kind of an important case. And maybe, AJ, you could talk about this in your experience. But in this case, there was a privilege clause that said, okay, we don't necessarily have to award this contract to the lowest bidder. We can use our discretion, of course, and you have to, the word reasonable is in there, even though you don't read it. It has to be reasonable discretion to award it to somebody else if we think that that's right. So that's not just a, let's be arbitrary. This is, if we really have a good reason to award it to somebody else, and we can demonstrate that, then we might not accept the lowest bid. In this case, Newcastle was doing a procurement, and they awarded the second lowest bidder the contract, and they said, look, our idea about value for money is not just whatever price comes along. There's also our experience with this particular vendor. There's how much we believe it's going to cost, what the cost of ownership will be, maintenance, all that kind of stuff. So they took a kind of an enlarged view of what cost is, which is another way of saying they took a long view about value for money and awarded it to the second lowest bidder. And there was a challenge, and the buyer was found to be correct in exercising its jurisdiction that way. Well, have you found that, AJ?
I have, yeah, and particularly when doing something like this, of not awarding it to the lowest bidder, but awarding it to the most advantageous bid or the best value bid, I think this leads into a practical consideration of the importance of record keeping in the analysis of bids. It's critically important, and particularly in a case like this where a buyer is not selecting the lowest bid, but those on the evaluation committee each independently taking detailed records and keeping detailed notes. because I think that this case could go either way if there was an insufficient evidentiary record or support from the people within the buyer, within the municipality or whatever entity it may be, if they didn't have detailed, specific considerations for fairness, because if it does come across as arbitrary, where you're not selecting the lowest dollar value bid on its face, it's critically important to defend that.
Yeah, this is sometimes being, referred to as an obligation to be open and let the light shine through your procurement. But I don't actually think there is an obligation at law to have everything kind of transparent. That people say that, but really what we're talking about with transparency is just being able to reproduce evidence that you followed the right process, and that it was the process contained in your procurement document. Really, really important. Mm-hmm. So. Transparency is one way to get there. If what you're doing is kind of open book, then it kind of speaks for itself. But you can be less transparent, if you will, during the process, as long as you can prove that you did all the right stuff. Then you're good. Do you agree, AJ?
I do. I think it's important to be crystal clear in the procurement documents that you may consider other factors, and what factors you would consider, so people who are involved in the process, even if they lose, they're aware of what the rules of the game were.
So AJ, let me ask you something. You were in-house prior to coming to Aaron Burles.
I was, yeah.
The drafting those procurement documents is a challenge. We're talking about trying to be transparent and putting all the rules of the game in that document. How difficult is it for municipalities or anybody, but municipalities where there's financial constraints, to get it right in those procurement documents?
It's very challenging in the municipal and public sector context, because it isn't usually one individual who's solely tasked with drafting those documents. There's a number of stakeholders that are coming to the table, whereby it's different technical individuals who have the need. There's involvement from risk, from legal, from a number of different entities, and maintaining the consistency of the documents is certainly a challenge, and the timelines to be able to get all of those folks to the table to be reviewing that document is certainly a challenge.
So there needs to be an appreciation that this is a significant undertaking, can take months if not longer. Absolutely. To get everything in those documents, which is in and of itself a significant allocation of resources of taxpayer money. And then you do your best with the limited resources that you have to kind of get it right, and then you face these challenges. It's a difficult situation for many.
Things go wrong. Examples of things going wrong are you get one bidder. That can happen. You get one. How do you know?
Or no bidders.
Yeah.
Sometimes you go through all of the effort. Everyone has sort of come to the table. They've spent a number of months of lead time, and they desperately need this good or service. And it goes out to the market, and for whatever reason, sometimes the market is too busy, or they're not interested in the work, and you get no bidders. That's also it.
Or you get two bidders and both of them have non-compliant bids. Then what do you do?
So what do you do with that?
You call the lawyers, and the lawyers go on the one hand, on the other hand, and on the other hand, you can get up to 5-6 hands with one question. No, when you've got a couple of non-compliant bids, you may have to withdraw the RFP and reissue it because it's still non-compliant. Somebody, of course, the exposure to being sued is less, because remember, in Contract A, only a compliant bidder has the right to sue under Contract A. But everybody has the right to phone the newspaper, blog about it, and tweet about it, and just make you feel terrible. So, it's important to get that right if you can.
And the point that AJ, you raised, which is a scenario where there's no bidders. You mentioned a few reasons. What do you think you can suggest to people to sort of avoid that situation? I think you mentioned that the market was too busy, or maybe it's just such a discrete product or service that it's not available. So can you talk us through some practical suggestions for people to avoid that scenario?
A key practical challenge, particularly in the construction space, is timing. If you're doing roads projects or other infrastructure projects, sometimes it's just a question of getting out there early. If your procurement comes out too late vis-a-vis other opportunities for people in the market, then you lose out. Sometimes you need to push the timeline earlier to have that sense and experienced personnel in the municipality for tracking how the market is going in that respect is critical. But I think probably the most important might be timing, and then also clarity. Sometimes the bid documents are not clear enough for what the municipality or the entity is looking for.
Now, that could come as a result of being in too much of a rush because of the timelines you talked about, right? Mm-hmm. They haven't got time to spec it properly.
Absolutely.
So you've got some practical issues of the resources involved in trying to get the bid documents together, which is a significant undertaking, but also the resources to go out to the market to figure out, is there a market for this? Is this the right time? What can we expect? So it's not just the internal procurement documents, but it's the practical environment in which those bid documents are going to be circulated that you also have to understand and plan ahead. So there's a lot of resources being tapped on all the entities, whether public or private, on getting this out there, getting this right. Because if you send a bid document out and there's no bidders, that's an incredible waste of time and resources for any organization.
And also to ensure that your contractual terms that may or may not be included in the bid document are commercially reasonable. Sometimes maybe the terms required are not commercially reasonable, whereby bidders just don't want to take on a certain amount of liability associated with that. So if that's a continual problem, it might be something for the organization to set up a working group or get people around the table to see if that's something that should be considered, particularly in the technology space.
Oh, yeah. But we see awful things in the technology space.
Ownership.
Clauses, especially that one, a buyer will say, sell us your product, and by the way, we own all the intellectual property. Well, no, we want to still be in business after we do business with you. So they'll run screaming from that procurement, or object to it, and then there's a problem, because a lot of times procurement agreements will come with a baked-in agreement, definitive agreement. It helps save time. If there's an agreement there, everybody knows what to expect. And you're asked, that one of the mandatories, you have to sign this particular agreement. Well, no, we can't. So if you say you disagree with the agreement, then you're not compliant, and therefore your bid is not compliant, and therefore it gets rejected.
So I know we're jumping a little bit, but we see that all the time when we're negotiating with provincial, federal government entities, especially in the technology sector. Right. They give you terms that are just commercially unreasonable. Ownership is really a key one, but also a limitation of liability. And so what's your suggestion from a practical perspective? If you're the seller, if you're the one bidding on this, how do you manage a contract B that you have to accept in the contract A environment, which is just beyond something that you would traditionally agree with?
Well, this is not a recommendation. This is just an observation.
Disclaimer noted.
I'm such a lawyer, some mornings I just wake up and I don't know. Anyway, I have seen people say, yes, we agree with everything, And then after they're awarded the contract, they sit down and then there's a negotiation over the very contract that they've agreed to sign, and they don't sign it. I have seen that backfire. It's not uncommon to see you will sign the contract within 5 days, and if you don't, you're not compliant. And then they're kicked off, and the buyer goes to the next bidder, next lowest price bidder, because the contract was not signed. In construction contracts, you see this kind of thing all the time. There are a lot of sort of standard form contracts. The municipal sector has their own that are kind of like the CCDC construction contract. So let's say you're doing a CCDC 2 type construction project. There's going to be a whole bunch of special conditions that are in there where the municipality or the buyer has said, we've thought about these. We want to cancel some of the standard conditions that are in the standard form, and we want to substitute these instead. Well, good luck trying to deal with those, right? This has been thought about. If, on the other hand, you want to add a condition that changes something that's in the standard agreement to tweak it a little bit, the number of days, something like that, who gets notice, those kinds of things, those are all minor, and usually you can do those changes even though the standard form of agreement is baked into the procurement.
I know in the technology we've got industry groups that lobby the various governments to change their mandatory terms, and they do that on an ongoing basis to try and get them a little bit more commercially reasonable.
Yeah, the folks at Buy and Sell Canada, for example, are pretty good at listening, and I don't know how often they do changes, but I know they're open to listening, and you can actually speak to them, and they've got reasonable people there who will talk to you. So, we've got about 15 minutes left. Do we have any questions from, no, nobody's out there listening. We actually had a few that came in beforehand. One of them is municipal sector procurement policies and the impact of those policies on technology sourcing and service sourcing. So how do you, I guess this is a good question for AJ, is how do you kind of handle a technology procurement or a service procurement for the municipal sector where there's an issue of balance? How do you make that sort of work when there's a disconnect between your policies, your buying policies, and what the public is willing to offer?
That may be an opportunity, again, if it repeatedly occurs, to revisit the policies, because sometimes the policies were created a number of years ago, and in my view, they're not meant to live in the past or be static in time. The policies can always evolve, particularly in the technology space with the constantly evolving and changing nature of service offerings.
Yeah.
And the policies, that goes back to the discussion we had earlier about the mandatory and the permissive. The policies also can be made to be more flexible and adaptable. So there are a lot of changes that can be made there.
The other thing, I think, and this is really important, and it was illuminated in the case, the Rankin case, which, let me just put that up on the slide number 5, Rankin against Ontario. There was a suit there because of this very area that AJ just talked about, where the city had its own procurement policies. It violated the procurement policies. and went ahead and did a procurement that essentially flew in the face of what its own governance requirements were. An unhappy bidder sued, saying, "Well, you violated your own policies. That can't be right." And the Court of Appeal here in Ontario said, "Well, maybe it wasn't right, but that's not for you to complain about. The procurement policies were not incorporated into the procurement document, and therefore, because those are not in the procurement document, they're not binding, and therefore there's no breach of fairness." Interesting, huh? It could have just as easily gone the other way, I think. Mm-hmm. But it does indicate that at least a municipality, if it wants to be a little bit flexible, can hold its nose and have a momentary mental lapse over the contents of its procurement policy and still have a valid procurement, provided that it obeys all the other rules. The thing that jumps out, I think, in terms of the principles that apply are, what is fairness? And everybody thinks that they know what fairness is. It's something that leaves you feeling like you've been fairly dealt with, or you don't feel resentful. But lawyers don't want to talk about feelings. We don't even know what those things are. So the fairness is essentially process-based. You can have the wrong result. Procurement law says you can have the wrong result, provided that the process has been fair from beginning to end. So, and actually, if you think about it, a lot of life works the same way. Courts are that way. Courts convict people who are innocent. Courts acquit people who are guilty. But as long as the process in between arraignment and well, actually arrest and verdict, as long as that whole process is fair, then you can say from a practical point of view that the parties have been fairly dealt with. And that essentially is the law in connection with procurement. Privileges clauses do work, generally speaking, but you have to be able to objectively justify the application of those clauses. You can't be capricious or arbitrary about it. And you certainly can't give an unfair advantage to any bidder. That, those are the things that will get you into trouble. It's all about process, and as AJ said earlier, it's all about documentation. You've got to be able to demonstrate through records that are made at the right time that you've done all the right stuff.
Let me ask you a question on the fairness, because sometimes when you're drafting procurement documents, you draft them so specifically that there really is only one party that can satisfy those.
The fix is in.
The fix is in, practically. So everybody's subject to the same term, but practically speaking, there's really only one company out there that can do this. Is that fair?
It's arguable that it isn't. In light of the terminology, particularly in the trade agreements, if there is another entity, if you could have worded it about the outcome that you're seeking, mm-hmm. and you could have worded it in a different way, it would be interesting to see. There haven't been cases on this point yet with respect to CETA and municipalities, but if you were to draft it in such that way, I think there may be an opportunity for a challenge or an issue.
Yeah, I think so. It's actually, interestingly, there's a question here from somebody. We won't say who his name is, what his name is, but or her name, could even be her. That public procurement in Canada, and specifically Ontario, is coming under greater scrutiny. The bar has been raised for greater scrutiny and transparency, fairness, and conflicts of interest. I have witnessed many situations where staff have been attempting to manipulate the outcome of a procurement to favor their preferences. And by the way, just my own observation, it doesn't mean that they're bad people, and it doesn't mean that their preferences are wrong. It just means that they're trying to favor a particular preference. I actually had to put my job on the line to avoid doing things that are in conflict with my public procurement code of conduct and what is in the best interest of the public. Could you comment on your observations and experience with municipalities in this regard? In other words, this procurement officer wants to know whether he's the only one who's seeing this kind of thing. I have actually heard of it happening in all kinds of public procurements. It especially is the case, and you have to be particularly vigilant, where you've got special interest groups who have to use whatever is being bought. And so let's use a hospital as an example, because it's not a municipality and we don't want any blowback on this. But so it's a hospital, and the hospital is going to buy some equipment for something, heart monitors or whatever. Well, turns out all the cardiologists love Acme heart monitors instead of beta heart monitors, whatever. And so they put all kinds of pressure on the procurement folks. Let's decide in favor of Acme. But of course, beta comes in with the lower bid with specs that are exactly the same. The heart doctors are unhappy because they're kind of used to the Acme stuff and they don't want to have to learn something else. The result is tough luck for the doctors if the procurement process is faithful to the law. I mean, it has to be like that.
We all have to acknowledge that most environments, municipal or organizations such as hospital, they're close-knit, people know each other. There are just inherent biases towards one product or one company or working with a particular person, and these rules in terms around fairness are there to try and strip away those biases to give everybody a fair shot. So we have to recognize those biases that we bring to the table and try and remove them so that we get the best result through the process.
Yeah, and we also stay out of trouble with the trade agreements. Yeah. Because you can be sure, I've got some experience with procurements in Europe. If you think that it's bad here, they really take it seriously in Europe. Probably one of the things we should talk about, based on a question that's here, is these privilege clauses. There's one question here from my friend Desmond, who says, look, if you don't award to the bidder with the lowest price or the highest scoring bid, in terms of points, doesn't it make a claim by the bidder with the lowest price or the highest scoring bid more likely, even though there's a legal privilege clause? Yeah, it does. And here's why it does. The issue is that if you've got a privilege clause that says we reserve the right not to award this to the lowest bidder, there's a caveat, an invisible caveat around that it has to be non-arbitrary, has to be reasonable, has to be commercially defensible. There's got to be good reasons for exercising that privilege or that reserved right. You can't be capricious about it. And so it does make a lawsuit, even if you've done everything right, more likely because somebody might take a shot and say, well, maybe I do have a chance of proving that it was capricious or arbitrary. Right, AJ?
Definitely. And in the course of their lawsuit, they would have rights to discovery, to go through the documents, not just the documents you put in front of them, but the documents that exist.
Yeah.
And their rights under Freedom of Information request to really get the details. It's not solely what staff or whomever are wishing to create in terms of the narrative. It will be the documents that really are the narrative.
Yeah. But on the good side, they have to hire a lawyer to defend them, and that keeps people like me off the street.
We just got a whole bunch of great questions come in, which dovetails on this last comment that you made, which is clients often ask whether they should appeal or contest or otherwise, what they believe is an unfair procurement decision. Given the uncertainty of any type of result in court, what's the best way to guide a client who is unhappy with a procurement decision?
Well, it depends on who the client is, right? Because if it's a federal procurement, they may be able to go to the CITT. There are options that are other than court. The first place to start is the bid protest process that is required to be in at least in the Ontario public sector and the broader public sector here in Ontario. It's mandatory. There has to be a bid protest mechanism of some kind. So that's a good place to start. And I guess, AJ, you're probably have been the point man for some of that stuff, right?
Not me directly, but I have been tangentially involved in bid protests, and it is certainly the best place to start in an entity to challenge the process internally, at least to get fact-finding and information that may satisfy the concern at the outset.
Yeah.
There's often a debrief interview after the bidding process is over, and then that challenge. Another question. We're not going to get to all of these, so I'm just going to start rapid firing them in the last couple minutes here. One of them, we're public sector healthcare and looking to post one RFP for multiple systems with multiple contracts. Have you ever negotiated multiple solution contracts, and any learnings to share?
I have. It's really dangerous and crazy and hard to do. Because there's always the sort of integration issue of how you get people to work together, and how many butts you have to kick in order to get compliance from your vendors after the process is over. So you've got the issue of how do you do the procurement, because then you're essentially asking groups of vendors to align themselves in some way. Some of those vendors will be common to all groups, right? There'll be certain subcontractors who will just say, well, I'm going to be available for group A, B, C, and D. And then after you select the syndicate or group that is going to supply the multiple systems with multiple contracts, usually also licenses in particular, how do you govern that whole relationship afterwards? And sometimes you have to sit down and think about what's your governance structure going to look like in the course of all that. It's great.
I think we're down to the last minute. I'm going to ask one more question, and it's: I find municipal council to be wary of the situation when they get bids that are too high to go back and ask the bidders to sharpen their pencils. What do you think?
Oh, AJ.
You've got about 30 seconds to answer. Should you be afraid to tell people to go back and try again?
Well, you really have to look into the details of the particular procurement document and what your privilege clause is and the nature of that, because you do go into a bit of a challenging waters where you have a number of compliant bids and you just simply don't like the price.
Yeah, you can't go beating up vendors just because you don't like what they want to sell you the TV for,
And you may get into challenges of arguments from the sellers because they've opened themselves up and they've given you all of this information, and they may make a claim that the process is unfair. You're just going on a fishing expedition for information, and you didn't actually intend to award it and you want to structure things differently based on the information they've provided. It's a challenging, tricky scenario
So
to
let
take
me
that
just
approach.
throw this out there. You get a bunch of bids and you don't like them. Can you just say no?
Well,
Walk away.
if you have reserved, which you always do, the right to withdraw that procurement, go back to the drawing board, then that's what you have to do.
Okay, I think that's it. We actually ran a little bit over time. Our apologies. We wanted to thank you very much for spending your Wednesday morning with us, or
Thanks,
part of
everybody.
it.
Thank you.
We look forward to you attending our future webinars. Have a great day.
Bye, everybody.